The owners of the dive boat that caught fire off the coast of Santa Barbara are now taking legal action to protect themselves from lawsuits.
Here now to break it all down, Fox 5 legal analyst Wendy Patrick. Wendy, good morning.
Good morning.
First of all, the optics on this are not great for the people that are doing this. But this is standard operating procedure.
That's right.
That's what people really need to understand. The timing is just a little iffy.
Well, and you bring up two great points. So the predictability of the suit is there. It's something that you see. It's like it's pre-Civil War. It's been going on for years. It's actually what the owners of the Titanic use. This is a lawsuit that's used very frequently. The optics of it, different entirely. I would put this into the category of awful but lawful. This is one of those lawsuits that anybody who knows anything about these kinds of tragedies would say it's just a matter of time. And it's somewhat of a race to the courthouse because it makes a difference if claims are filed in state court or in federal court. So it's a preemptive strike by the owners of the boat, but it's something that you often see insurance companies doing. So the proactivity involved in getting out in front of what no doubt was going to be wrongful death lawsuits coming at them, probably from all sides, given the number of people that perished in this tragedy, not unprecedented and not a surprise in this instance either.
So this is something that the boat company is doing to protect themselves. They're getting ready because they know that the lawsuits are going to be filed.
That's right. They know they're going to be filed, but they also are maintaining that that ship was both safe and seaworthy. Now, investigation is continuing. I mean, certainly it's just begun. The accident just happened. But this is one of those things where they're going to see, well, was everything maintained properly? Was the boat designed correctly? And if that's true, can they then limit their liability to what? The loss of the ship? It's worth basically nothing right now because it's destroyed.
This dates back, you mentioned, to before the Civil War. I think the year was 1851, based on what we researched here. Does a court take that into consideration? And at what point do you start maybe thinking, do we need to update these laws to make it more timely for the era we live in now?
These are great questions, and I know that both of you went to law school briefly, so let me appeal.
The best week of my life,
Wendy.
Yes, thank you.
Let me appeal to your legal minds. You're right. Well, court will always look, well, when was this law put on the books, and does it make sense now to maintain the law as it was written back in 1851? But remember, it's been invoked over the years. So sometimes when you have laws that are tried and tested throughout the years and are still on the books, it's for a reason. The optics of it, and what really is the unfortunate part of a law like this, is it forces those grieving families to now find a lawyer because they have 6 months to basically dispute the claim that the boat owners did nothing wrong. So that's the problem from a human perspective. So a court looking at this law will look, number one, does it still make sense? Is it still, or does it weigh too heavily in favor of the boat owners? But also, does it make sense in this particular case? So a lot to look at in each one of these cases that are filed.
Anywhere you go nowadays, the doctor's office, you go ice skating, anywhere you go, they usually give you a little piece of paper and they say, sign here, and you waive whatever liability you have so that...
The paper almost nobody reads.
The paper... Good point.
Thank you.
That almost nobody reads.
Right.
But we sign it. I'm only assuming that when you're going scuba diving, you're signing some type of document. This is an assumption. What does that, if that had was a play in this, what would that mean if these people signed these waivers?
Well, I would always start with words matter. You do want to see the way things are worded when you are signing some sort of a waiver. And you know what happens is every time we have a tragedy like this, and our prayers are with the surviving family members of those that perished in this accident, but you do for a period of time always want to look, well, if I'm engaging in an activity that even could be risky, what does it say? Is there an issue about negligence, or is it recklessness, or is it an unforeseeable risk of harm? That's the only thing that I'll be able to sue for. So it's worthwhile to read those waivers, but many people, you're absolutely right, they're not going to stop engaging in the activities they love merely because life is unpredictable in a sense that you just never know when something is going to happen.
And despite all those waivers, you find a good enough lawyer and they will always find something in every single thing you've signed. I said, don't worry about the waiver. And
that's the other side of this as well, is you can't simply say you can contract out of anything that might possibly happen that could harm somebody that signs up for an activity. And suffice it to say, that's not only why these head towards court, but they're also why a lot of them settle.
So I was curious about, putting forth this lawsuit, if the investigators find that there was negligence on their part, does it then invalidate what they're doing right now, or does it then make it more complicated?
It makes it more complicated on a number of different levels. So they've basically got out in front of this and said, we're not liable, it was safe, it was seaworthy, there is no negligence. If in fact there's some serious design flaw or something about the way that boat was equipped that's found to be at fault, then you're right. You are into an entirely different ballgame.
Wow.
But that's not to say that it's a slam dunk either way.
Sure.
I did say many of these cases settle. The ones that don't often make new law, the kinds of laws that will guide us. I hate to say, if God forbid this sort of thing happens again.
One of the investigators, I know it's going to take probably up to a year to figure out exactly what happened, but one of the initial responses was one of the safety investigators that was shocked at just how small that emergency exit supposedly was.
And how cramped those
quarters
were
like a little thing that you open up.
Right.
How are 34 people supposed to, in case of emergency, use that?
Yeah, and when you do look into those types of incidents, you find that in many types of activities you engage in, there are quarters that not only are cramped, but there are limited access to escape. So again, on the front end, what they want to look at is, was this deemed safe for this vessel, for this excursion?
Yep.
So if the answer is yes, that's one of the problems that many of the wrongful death actions. It doesn't mean that they're not going to be successful, but you're right that it complicates things.
Okay, Wendy Patrick, thank you.
Yeah,
Appreciate
thank you.
it, as always.